coming up.
Who else would be subject to your investigation? Like, we're talking about with respect to ArriveCan.
Does there need to be a public reporting mechanism? Because certainly I would like to know that the 6 cases that you've referred, what the deal is with those.
Commissioner, I'm having a very hard time with this.
This guy's garage. Like and subscribe.
It's always a pleasure to have Carolyn Maynard here, who is the Commissioner. Ms. Maynard, welcome to committee.
Bon matin, Commissioner. You're currently investigating ArriveCan, is that correct?
Yes.
We've heard that Min Doan, who's the Chief Information Officer of Canada under this Liberal government, destroyed or attempted to destroy over 1,700 emails relating to ArriveCan. Is that what you are specifically investigating?
I cannot talk about my complaints or the investigation I'm doing, but it is part of the overall investigation, given that I started my own investigation.
What was the trigger for your investigation?
Well, the number of complaints that we received, the allegations that we saw, the testimonies that you've heard was sufficiently serious that I decided to initiate my own investigation into the affairs of CBSA and ArriveCan.
Are you able to tell us if you've interviewed Min Doan?
No.
No, you're not able to tell us.
No.
He has not cooperated with parliamentary committees investigating his role in ArriveScam. Are you able to compel testimony from Mr. Doan or others who you wish to interview?
Yes, the Act allows me to.
Which Act?
The Information Access.
Have you been able to obtain, are you able to share with us if you've been able to obtain copies of the up to 1,700 emails that are said to have been deleted?
I cannot confirm that.
Are you able to tell us if you have the power to order the production of those emails or any other documents that are relevant to your investigation?
Under my Act, I have the power to subpoena documents and subpoena witnesses.
What are the penalties for obstructing an investigation or for someone refusing to provide documents or refusing to cooperate?
There's no penalty. The only thing I can do under the Act, if I find that somebody is intentionally refusing to cooperate or refusing to provide documents, or if it looks like it's an intent to not provide access to Canadians of some documents, I can refer it to the Attorney General. As soon as it becomes more in the gray zone of criminal intent, I cannot investigate those allegations.
Are you able to say what the remedy is that the Attorney General would be able to offer?
No.
Have you done that in the past?
I've done it 6 times.
Do you know what the outcome of those 6 referrals were?
I've never been aware of an investigation.
So we've seen key players in the $60 million ArriveScam lie to parliamentary committees. We know that the House found one witness, one individual, to be in contempt for prevaricating and refusing to answer questions. Are you witnesses that you interview sworn in? Do they take an oath before you take testimony from them?
We can ask them to be sworn in an affidavit.
And anyone who swears an oath can be charged with perjury, which carries a penalty of up to 14 years in jail. It's an indictable offense. Is testimony to you protected by the same type of privilege that people who testify at parliamentary committees enjoy?
I don't believe so.
So the cases that you refer to the Attorney General, to the Crown, could be referred to a prosecutor for charges of perjury, as an example. That potential exists.
That would be in the purview of the Attorney General's decision, yeah.
But for the half dozen, and could you tell us over what period of time you've made referrals?
Over the last 4 years,
Okay.
the Office of the Information Commissioner has referred 6 cases.
Are the details or the specific cases that you referred, is that a matter of public record?
No.
Is it confidential?
It's, you can access it under the Access to Information Act.
So would one need to file an ATIP with your office to get that?
I believe if you do an informal request, we probably can provide you some information on these
Ms.
cases.
Maynard, would you be willing to provide that information to the committee?
I will.
Thank you very much. Who else would be subject to your investigation? Like, who, we're talking about with respect to ArriveCan. Are you able to share with us what your scope would be, or is that details that you're unable to share?
I cannot, yeah.
Have you so far seen cooperation from the people or from the entities or individuals that you've contacted in this investigation?
I cannot confirm.
Are you able to share with us the anticipated or your target completion for your work? Is that something that you forecast?
I'd like to finish before the end of this year.
The end of the calendar year?
2024, yeah.
And that would mean that you would have, that you'd be able to report on it by that time?
Yes.
Okay. You mentioned how much time do I have left, Chair?
25 seconds.
Commissioner, thanks very much for your response
You're
to my
welcome.
questions. I appreciate it.
I appreciated your comments about making sure that your office functions effectively, and a lot of that has to do with funding as well. Now, I do note that in December of 2023, the opposition voted against funding for the Office of the Information and Privacy Commissioners as a whole, and as you've said, without... Please don't interrupt me. I don't interrupt you when you speak, Mr. Barrett.
I don't want any disruptions here. Keep the comments down, and I accept your apology, Mr. Kirk.
I didn't say anything.
I thought it was you.
So it was Mr. Kirk. I heard it.
My apologies to Ms. Khalid in the chair.
Okay, so I accept your apology, and go
I
ahead, Ms.
expect
Khalid.
well.
So
Absolutely. I apologize, Mr. Barrett, for thinking
you.
that you said something that Mr. Keurig said instead.
It was well said. Well said.
we are going to continue. I did stop your time. In fact, I'm going to give you the 25 seconds back. You have 6 minutes. Go ahead.
Thank you very much, Mr. Chair. So you had said that without additional funding, I will no longer be able to carry out my mandate responsibly and ensure full respect of Canadians' rights to access to information. And these were the words of the Information Commissioner when Harper was in power and when Pierre Poilievre was minister responsible for safeguarding our democracy. Now, do you worry that receiving ample resources in the years forward or not receiving them is going to hurt how your office effectively functions?
Having sufficient funding is always at the heart of my mandate, because I cannot. I don't know how many complaints we're receiving. I don't know how many investigation we have to do. So this is why I was asking for an independent funding mechanism, so that if it goes down, we can reduce the funding. If it goes up, we can ask for through a mechanism that's faster than the current mechanism that we have, that it's providing us with sufficient funding.
I appreciate that. And so as you're entering your final year of your mandate, what challenges do you see going forward for your office? You
referred to the former commissioner, and it's interesting. If you look at the testimony that she did in 2015-16, there's not a lot of differences between what we said back then and what we are saying now. Is the Act needs to be modernized. The government has to change the way that they deal with access to information. They have to be more proactive. They have to provide information, because the Access to Information Act is not now responding to the demand. So we have to do something. We have to invest in our resources. We have to manage the information better. And I don't see, since when I started in 2018 and now, it hasn't improved. I don't think it's going to improve in the future either if we don't change.
I appreciate that.
In your opening comments, you referred to your work as a quasi-constitutional right that must be upheld. And you referenced institutions that were negligent in responding to your requests for access for information. I believe you said that there were 4 actions currently underway. Which institutions are those?
There was 4 application of mandamus produced against one. The first one was against Trans Mountain Corporation, TMC. That application was settled. And then I had to apply for a mandamus against National Defense 3 times. And one has been also found to be moot because the request was responded to. But we still have 2 active applications
against the Department of National
Defense. Yeah.
So 3 actions, one of them moot because you had to actually take them to court using your own resources on a budget that already has a structural deficit baked in. There's no punishment for not following your orders. In your estimation, does that not incentivize departments to not comply if there's no real repercussions?
It's the fear that we have in my office right now. We hope that it's not going to become a norm.
And with the Department of National Defense, given the strong mandate that you have and all the agencies and institutions that are prevalent, that this one 3 times has required this, does this not speak to a culture within the Department of National Defense?
Whether it's a culture, whether it's a lack of resources, the priority definitely has not been provided to providing access or the appropriate resource to respond to these requests at National Defense.
I would put to you that in my short time, 4 or 5 years here, one of the frustrations I have coming against the idea of open government, the idea of being open by default, the idea of having parliamentary privileges, is that in practice we're often left with very little information to make informed decisions as decision makers in the House of Commons. It's something that we wrestle with. I don't think it's a partisan issue, quite frankly. I think that there's members of all parties who would agree. And in that regard, I think that it's part of our mandate and duty, Mr. Chair, to deal with these things. Now, we had a situation that was a once-in-a-century type situation yesterday because somebody refused to follow the very basic premises of our abilities to send for documents, order for evidence, and make witnesses appear. My concern, and we've seen this with other studies that we've had right here at this committee, is that if people know there's no consequence, then forget about open by default. There's going to be, I think, a culture of cover-up by default, secrecy by default, obstruction by default, negligence by default. And for that reason, Mr. Chair, I wonder if it might be wise for us to seek unanimous consent on a motion that would draft a letter from this committee to the Department of National Defense, urging them, we can't direct them, that comes from the House, recommending to them that they comply in good faith with our Information Commissioner. The fact that we have, a cash-strapped commission having to take legal proceedings, the fact that in the House of Commons in the last session of government had to have the Speaker of the House go after the government to get information is a problem. But in this situation, I think in a nonpartisan way, by seeking unanimous consent, a letter comes from you to the Department of National Defense asking them to comply with the demands from the Commissioner in accordance with the Act and in accordance with her mandate. It's not something I want to get into a filibuster over.
Yeah.
But I do think the testimony we heard is compelling. One department has a pattern here, and I think that should be a request. It's a very reasonable, rational request that's not a demand.
Okay, so I'm going to stop you there and accept that as a motion.
Thank you.
And I think it's a reasonable motion as well. And of course, now that the motion's been moved, we have to seek debate on that motion. And I appreciate the fact that you don't want a long debate on it, but I'm going to open the floor. And Madame Maynard, if you can just hang on for a sec. I see Ms. Khalid on what Mr. Green has proposed, and then Mr. Barrett. Go ahead.
Thanks, Chair. Just seeking clarification, is there something similar going on at the National Defense Committee?
I wouldn't know that.
I have no opposition to this.
Say that again? Okay, thank you. Mr. Barrett?
Yeah, this makes great sense. Appreciate
Okay.
the motion coming forward. We'll
Yeah.
we'll support it. Mr. Green is in the process of reading minds down the table. I was going to say that we should make it time bound, and so I'm not sure if similar requests have been made. I don't personally have a suggestion, but that they should comply sometime in the future. I'm sure they've made overtures that at some time in the century that they will, but that's obviously not acceptable. So make it time bound, but certainly it has our support.
So I'm going to seek some guidance from Ms. Maynard on this. What would be a reasonable timeline if the committee were to agree to what Mr. Green has proposed, in your opinion?
So what you need to understand is I already ordered the National Defense to respond to a request, and they said they would comply to the order. Under the Act, you either comply or you go to court. In this case, they said they will comply, and they didn't. They missed the date. So that's why I'm in court to force them to respect an order that has already been issued.
Okay, so Mr. Green?
So the timeline is it's already too late.
It's passed.
I just reflect in terms of our order of operations that my fear is that we'll have the same treatment unless we put a date. And so, I think if it's 2 weeks for a response from the time of the passing of the motion, then that would at least give them the opportunity to respond to this committee with what their intention is.
So I'm going to seek unanimous consent on what Mr. Green proposes. Okay, we're good. Not seeing any dissension. Okay, so that motion carries. We're going to continue on. Unfortunately, that's the end of your time, Mr. Green.
Yep.
You talked a little bit about the quasi-constitutional right to access. Maybe that's something in a perfect world where that would be articulated as a constitutional right, because I think that open and transparent government should certainly be the default, and it is incredibly frustrating that we have this culture of secrecy that exists. And I would like to, in a little bit of a follow-up to the conversation, so you referenced, and I apologize if I missed it, but there were four of the six. You referenced six in your opening remarks. One was with TMC, four were with the Department of Defense. Did you mention what the other?
It was 6 to the referral of the investigation to the Attorney General, but 4 application of mandamus, 3 against DND and 1 against National TMC.
Okay, I appreciate that being clarified. So there are those 4 current proceedings before the courts. Now I think that we find ourselves in an interesting circumstance because you being given order-making power, and it would have at one point in time been seen to have been enough to name and shame. We've had similar conversations with now a series of ethics commissioners where a $500 fine for breaking the ethics rules was at one point seen to be the punishment of being exposed to have broken the ethics rules was enough. And certainly, you having been assured in the beginning that, don't worry about it, no penalty, it's not a big deal, because of course they'd want to, and I'm being a little bit facetious here, but Madam Maynard, Commissioner, what would be an appropriate penalty to ensure that that we don't have this culture of secrecy perpetrated upon ultimately Canadians who are denied access to their information?
It's really hard to tell what would make institutions understand their obligations, the fact that it's important that they respect the law, and that the requests must be responded within a certain time, and that the orders of the commissioner must be complied with. Who's responsible ultimately? Is it the unit who's responding, the minister, the people between? It's to find those, that would be a difficult task to determine where did it break. But a penalty, we don't have penalties under the Act. The Commissioner of Official Languages was just provided some penalties with his new Act. It's going to be interesting to see if that has an impact.
Right.
But I would love to have performance objectives where maybe, some people would be required to respect the obligations under the Act.
So, to pivot back to the when criminality is involved, you refer those cases to the Attorney General. It seems to me that it would be possible that that's a little bit like a black hole. You don't see the result of that, and certainly Canadians don't see the result of that. So I'm just wondering, does there need to be transparency in that process? So that if you see criminality, if there's that need for that referral, does there need to be a public reporting mechanism? Because certainly I would like to know that the 6 cases that you've referred, what the deal is with those. Are cabinet ministers implicated? Was there criminality within departments? Those are open questions that I think should be fair ones to ask. Yet we have this black hole currently that exists administratively, that from the good work that your office does, coming against the wall of prosecutions, and then all of a sudden it is a Liberal appointed Attorney General that is then responsible for the decision-making process of what to do with possible criminality that could have significant political consequences. Do you see a concern with that process?
Under my submission for the amendments to the Act, I suggested that it be changed to a referral to the appropriate authorities. So that would be opening my authority to refer to the RCMP or to another police authority.
Right.
But right now, it's very specific. It has to be referred to the Attorney General.
So there could be right now alleged criminality that is not being investigated because it would be easier for the Attorney General to simply make it go away.
Very quick.
It's their decision. It's within their authority to decide what they decide to investigate or not.
Wow.
Thank you.
Thank you.
Thank you.
In the main estimates, your office is asking for just over $15.3 million, which is an increase of 1.1 or just over 1.1 million over last year's. Can you tell me what that 1.1 looks like, what that represents, and how those funds would be used?
The last time we received an increase was in 2020, and it was with respect to the amendments to the Act. Anything we get, we invest in our investigators. The number of complaints that we receive are increasing every year. So we put that money into more people to investigate faster and to eliminate our inventory as quickly as possible.
So, notwithstanding the way you would like to see your office funded, based on the number of complaints, is this budget increase going to be sufficient for your office to fulfill the mandate? You feel comfortable with that number?
I didn't get an increase in the last 3-4 years. I requested $2 million per year for 3 years in the last budget request for a temporary funding, but that was not provided.
Okay, so this is the first increase then in the last few years? This 1.1?
I don't really know where the 1.1 comes from because the last time I received money was $3 million a year since 2020. Is it possible it's the Privacy Commissioner you're referring to?
No, the OIC. It's seeking 15.3 million, an increase of 1.3 over last year's main estimates.
I think it was provided to us in terms of. Now I think I understand what you're saying. It's the additional funds for collective agreements for all of our employees, because we are mainly under we have all I would say 75% of our employees receive an increase in the last 4 years.
Right.
So that would be covering that.
You said that you pledged to continue advocating for changes to the Act and to the system. And I'm wondering what those changes might look like. And I know you did touch on, I think you touched on one with Mr. Couric, MP Couric, but could you maybe talk in broad terms what those changes might look like?
Well, first of all, I think that the Act, because it's 40 years old, needs to be modernized in terms of like what it's the purpose of the Act. We need to, right now I don't have access to cabinet confidence. So those documents are not reviewed by my office. So that's something I think is problematic. because the section to say that something is covenant confidence is being used more and more, and there is nobody independent from the government right now investigating those documents. I think that they actually be also applicable to Minister's Office and the Prime Minister's Office as well. And
If I recall, you had mentioned there were 6 cases that you referred to the Attorney General, and yet we've only explored 4 of them that went forward publicly. So would you please share with committee what were the other 2 cases that were referred to the Attorney General but not acted upon?
So it's 2 different things. Like the 6 cases that I refer, or that the office referred to the Attorney Generals, were with respect to investigations where we felt that there was reasonable evidence of an intent to obstruct the access request.
Which ones were those?
So there's, I will have to send you a list because some of them have been before my time. But it's usually because we believe that there's a possible criminal charge coming up. The 4 mandamus are separate. Yeah.
Okay, just so for the purpose of this committee and for the purpose of the good and welfare of open and transparent government, I would put the request that you do submit that list of referrals to the Attorney General's office for reflection of this committee in response to the work that you're doing.
I'd like to circle back to the point that you've raised. You raised in my first round and in the round with Mr. Couric, talking about ArriveCan. So we have you have an ongoing investigation. I appreciate that the details of that you can't get into it, but we have allegations that a senior official, a chief information officer, Mindone, is alleged to have deleted 1,700 emails, maybe more, we don't know, destroyed documents in a case that is of great public interest. Obviously, this frustrated the work of the Auditor General of Canada, and certainly there's other potential investigations that are happening with the Royal Canadian Mounted Police. They've indicated that they are, in fact, investigating ArriveCan. So in an investigation, if you find that a government official has deleted or destroyed government documents, what is the consequence that is meted out for a violation under the Act?
So there's 2 things. Administratively, somebody could have destroyed or erased emails, and I don't have any penalty. There's no, like, if we arrive to the conclusion that the documents don't exist anymore, we can make a finding and we can produce a report. But if I find that there's reasonable evidence that it was done intentionally, so that it was to remove somebody from having access to these documents, my only authority is to refer to the Attorney General for future investigation.
Commissioner, I'm having a very hard time with this, and so we have a situation where individuals that you're investigating, like in the ArriveCan scandal, as an example, can lie to you, can commit perjury, can be found to have intentionally destroyed documents to frustrate investigations, and the maximum penalty that you can apply is a referral to the Attorney General. Is that correct?
My only authority is in those situations, yeah.
So herein lies the problem, because, as has been pointed out, the Attorney General sits in the cabinet, has been appointed by Prime Minister Justin Trudeau. This situation is incredibly politically sensitive for the government, and we have an independent officer of Parliament who goes to great lengths to get answers, to get access to information, to ensure that basic transparency laws are being adhered to, and the Attorney General, who, as I said, is a Liberal cabinet minister, is the arbiter of whether or not it goes any farther. And I just can't see how that ensures any kind of confidence in our public institutions and or the efficacy of the work that you're able to do. What's the solution to this?
I think separating the investigation of a criminal investigation to administrative investigations is the appropriate thing for an agent of Parliament. But as submitted earlier, it would be maybe better to have in the Act that I can refer these type of cases directly to the authorities in charge of investigating those type of criminal charges.
What's the precedent for that? Does that exist with other officers of Parliament?
If you look at the Federal Act for judges in the court, any court, judges can refer if they find during during a hearing, during a process, evidence of an intent to commit a criminal offense, they can refer to any authority that they want to.
What about the lobbying commissioner? Does she have to refer cases to the Attorney General, or
I don't know.
She refers them to the Royal Canadian Mounted Police? So I find it incredibly troubling that we have a situation here. I think Mr. Kirk rightly put it. We end up where they go into a black hole, and that's not how we restore confidence in our public institutions. Thanks very much.
I'm going to come back to Mr. Barrett's question. Was the Act amended since 2015 to change the provisions about how you would refer matters to the Attorney General?
No.
So it wasn't this nefarious act by the current government to change the law so that you can only refer matters to the Attorney General that existed while Mr. Harper was Prime Minister?
It's been like this since 1983.
Since more, before many of us were even born. Okay, thank you very much.